All right, there you see James Crumbley was in the Oakland County Circuit Court today. Just about an hour ago, the judge deciding who and who cannot testify in his upcoming involuntary manslaughter trial. And as we go ahead and take a live look outside of the courthouse, there are still a lot of questions to answer in this case about a possible change of venue and also if other text messages will come into evidence. Good afternoon to you, and thanks so much for joining me for the Daily Plus Live as we continue our in-depth coverage of the Crumbleys on trial here. It was the pretrial motions for James Crumbley's involuntary manslaughter case today. We actually heard from James Crumbley himself as the judge was asking him questions about his representation and if he understood why he had the defense attorney that he had. And also then the defense argued about certain witnesses that they did not want to see called in this case. First, it was a person who had previously owned the gun that James Crumbley ended up buying and purchasing, and then his son ended up using inside of Oxford High School. And then two witnesses to the shooting. Actually, they were students who were wounded. Prosecution wants to call them. The defense says they don't want them to take the stand. Take a listen to the arguments back and forth.
We added 4 names to the witness list. 3 that were identified as minors. 2 were actually have reached the age of majority.
I was going to ask you that.
Yes, Judge. So we would only seek to have those individuals testify. Initials KO and RF. Those individuals are both above the age of 18.
Are you abandoning your request to call HA?
That's correct, Judge.
Okay. All right.
So we have confirmed with their families as well that they are ready, willing, and available should they be called upon.
Okay.
So again, we did so with as much notice of defense counsel. Again, it was 30 days prior to trial because we are aware that this court does run a very tight ship. As the court recalls the last trial, we were delayed from weather. We had a witness who had COVID. We had another witness with child care issues. We had yet another witness who was on vacation. We had to reorganize our proofs and presentation on the fly. So we want to be able to present our case in an efficient manner. We don't seek to expand the record necessarily, but we do want to be prepared to have opportunities to present our case should one or more witnesses become unavailable for any particular reason.
Okay, well, I guess that's one of my questions because you have Molly Darnell and Christy Gibson Marshall, who testified in the previous trial, testifying in this trial as well.
That's correct.
Because I guess I read, I don't know if it was a free press in the Detroit News, interpretation of the addition of the witnesses that maybe they were supposed to take the place of other witnesses who felt too traumatized to testify. So,
again, I believe that was the interpretation, Judge, and if it was articulated that way in the motion, then that was.
I don't think it was. But
okay, thank you, Judge.
I thought maybe I was mistaken. So
I believe so, Judge. So
I'm interested in that.
Yes, Judge. They are available and they are cooperative and will be testifying in this case, Judge. Okay. Again, when we amended the witness list, it was right after they testified while the jury was still deliberating, and we are aware of the impact it has on everybody, not just civilian witnesses, but police officers as well. So we wanted to proceed in an abundance of caution. They have options should we need those options. But since the time that I filed, and I communicated this to defense counsel as well, and we had private conversations regarding this, and I said the intent was not to add a number of witnesses. It was to be prepared in the event that someone would have to drop out at the last second, Judge.
Okay, are you able to give the court an offer of proof with regard to KORF and as a separate issue, Kyle Keyser?
Yes, Judge. If I may, I'll start with Mr. Keyser. So Mr. Keyser is the original purchaser of the 6-hour 9mm handgun from the firearm store in Oxford. He bought that firearm in May of 2021. He used the firearm 3 times. He sold the firearm back to that same firearm store in Oxford on November the 13th of 2021. That's the gun that was purchased by this defendant, James Crumbley, on November the 26th.
Okay.
So he was added in response to statements made by Jennifer Crumbley's attorney during her presentation of the case, as well as Jennifer Crumbley's testimony. Now, I don't know what counsel's argument is going to be regarding the firearm. I don't know if Mr. Crumbley is going to testify or what he might say. So we added that individual. He's potentially a rebuttal witness. Obviously, we have no obligation to identify rebuttal witnesses. However, should the argument be presented in a certain fashion similar to that of Jennifer Crumbley, I think the background of that firearm, how it was stored, how it was bought and sold, would be relevant to the jury. So he was added after hearing the co-defendant's case in chief, Judge.
Okay, I'm not following. You're adding him for the purposes of rebuttal only?
Not necessarily.
Okay.
So, it depends. I don't know how counsel is going to litigate her case, and obviously she's under no obligation to let us know that.
I was struggling with the relevance he might bring to the case. So
again, he bought the eventual murder weapon in May.
Okay.
He used it 3 times. He was provided with a cable lock. He never used the cable lock. He identified that as the same cable lock sold back to the firearms store, which in turn will be identified by those witnesses as the same cable lock sold to Mr. Crumbley.
Okay, I get it now.
So,
all right.
again, and with KO and RF, both were students.
Well, let me make sure that Mr. Kieser would potentially be in your case in chief, but you're asking for him on rebuttal.
Well,
at a minimum.
Potentially on case in chief, and it really just depends on how the case progresses, Judge.
All right. Okay.
Thank
Go
you.
ahead.
KO and RF, Judge, both students, both wounded November the 30th, 2021. They were both in the 200 hallway, and they were struck as the defendant's son emerged from the bathroom adjacent to room 258.
Okay, well, I guess breaking this down, the fact that they were wounded is potentially not relevant. What they saw is potentially relevant.
Your Honor, while I can't imagine what those 2 students went through on November 30th of 2021, their testimony is not relevant in the trial against James Crumbley. He's been charged with 4 counts of involuntary manslaughter. He's not charged with assaulting anyone with a firearm. He's not charged with shooting anyone and wounding anyone. He's charged with 4 counts of involuntary manslaughter for the actions of his son. As the court correctly noted, Molly Darnell and Christy Gibson Marshall both testified in the prior trial and testified in relation to, I believe, in relation to the video that was admitted.
Would you agree that they were not in the same location as the 2 witnesses, KO and RF? KO and RF, did you say, are both outside the bathroom?
Correct.
Is that accurate?
The 200 hallway, it's been identified as the shorter of the 200 hallways.
Okay. I thought that in Ms. Lehman's motion, I think some of her information was gleaned from the victim impact statements and the shooter sentencing, but I think there was an indication that KO was a friend of Tate and that RF was staying somewhere else. Maybe it's AJ who rendered help, but
AJ,
right? But AJ we're not calling. So, are there? Would KO and RF be given the same testimony? Were they in the same hall?
it sounds like they were in the same hall, Your Honor. I believe Mr. Keese indicated they were standing right next to each other at the time of the shooting. Regardless, I don't think that either of them are relevant in this case, Your Honor. I think that the court can agree, and I think that Mr. Keese would likely agree that their testimony, the primary purpose of their testimony is to inflame the emotions of the jury. I mean, their testimony or whatever they can provide can also be provided in a video. The whole purpose of admitting the video and not having sound on the video was to lessen the prejudicial impact on the jury. We litigated this previously, and this has been discussed with the court. The purpose of the video and admitting the video is to show the jury what actually occurred during that shooting. The shooting is caught on the video, Your Honor. So the court has previously decided that the video is being admitted. I still don't believe that it's relevant in this case, Your Honor. However, I know that that's the court's ruling. So allowing the testimony of two students who were not only in the hallway but were also wounded by the shooter, Your Honor, I just don't find it relevant. And I think that it is, even if the court finds it relevant, it's highly and highly unfairly prejudicial in this case in light of the other evidence that the prosecution can present. And again, we've offered to stipulate to some of these facts so that these witnesses don't have to testify, so that the video doesn't have to be played. The prosecution doesn't want to do that, Judge.
Well, they don't have to.
And they don't have to. It's their case to present, Your Honor. However, when it comes to these two students, their testimony, even if the court finds it relevant, is unfairly prejudicial to James Crumbley.
All right, so that is what Judge Cheryl Matthews has to take into consideration right now. But she did make a ruling on the previous gun owner about being a witness. Let's get out to Rod Maloney, who was live, who was in court when this happened about just a little bit after 11 o'clock this morning. Hi, Rod. Why don't you go ahead and fill us in on what the judge had to say about both of those issues?
Well, Christy, she didn't rule on whether the students can testify. She's still taking that under advisement. We're awaiting a decision whether that'll happen today. We're uncertain at this point. But she also ruled that the prior gun owner is going to be allowed to testify. And they went over to great detail about how he had purchased the gun in 2021, used it 3 times, then went ahead and sold it back to the gun shop, and that was the weapon that was used. And the prosecution saying that they look to call him mainly because they can sort of get to the provenance of the gun. If, in fact, it even comes to that, they're not sure they're going to use him. And, in fact, they also said that the students that they were looking to call may or may not be called as well. The defense attorney for James Crumbley, Maria Lehman, is saying that essentially it would be highly prejudicial. We just heard her say that it's not fair to James Crumbley to have that testimony from the students who were in the hallway at the time of the shooting. She said they're already showing the video. Judges ruled on that. And she says that having the students talk about what it sounded like, what they felt like, what they went through as they were wounded in that hallway is prejudicial to her client. Also, the fact that they're showing the video without the audio, she says, is part of the reason we didn't want to further prejudice the jury against James Crumbley. She also says it's not relevant because essentially he's being tried for facts that led up to the shooting and not the shooting itself. So that's where they were dealing with it. One of the things that kind of gets lost in all of this, as you heard that testimony, is that there were 4 witnesses they were talking about today. 2 of them actually one of them will not testify. That's the student who was listed on the list, who was under the age of 18. They said that they're going to remove that person, that student, from the witness list. So there were now just 2 students who were in the hallway that are likely to testify, at least the defense, I apologize. The prosecution is saying they're not certain they're going to testify, but the defense doesn't want them talking.
Yeah, Rod, again, talking a lot about logistics in terms of keeping the trial going, that if for some reason someone has a problem with childcare, if someone gets sick, and that's what Marquise was talking about, right, that they have to make sure that they have witnesses that can supply the certain testimony that they're looking for in terms of forming that indeed this horrific event did happen. But, you know, making the point, the defense attorney, right, that they will be able to see video of the shooting that, right, and again, it's so hard to not try to compare what we just saw happen in Jennifer Crumbley's case, but this indeed is an entirely different case. Even though they are co-defendants, they're not joint defendants, and you see there's a different defense attorney who is taking a different tact here.
Right, and not only that, but she is asking for a whole lot more. In fact, there was a filing that was put out this morning that we just see here that I spent quite a bit of time going over, and she's trying to keep the shooter's journal and text messages out. The text messages were between the shooter and one of his friends, and the defense is saying that she doesn't want that in either because it's a situation where she can't cross-examine. In other words, the shooter has said that he's going to take the Fifth Amendment if he gets called in this case. And so if he gets up there and if he is brought into the case and pleads the Fifth, that they can't cross-examine when they talk about his alleged mental health issues and things like that. And so that's another thing that they're fighting to keep out of the trial. And so it's been kind of a pitched battle, and we're expecting another hearing on the 28th to hear about the journals, the text messages, also the change of venue, which did not come up today. The change of venue is something that they were asking for, and that was asked for over a week ago. And again, that will be heard next week in advance of the trial, which goes on March 5th.
Absolutely. All right. Thanks so much, Rod, for bringing that up. Again, yeah, there are a couple of more things that are still hanging out there. We appreciate it.